Okay, great. Hi, everybody. Again, I'm Erin Wilson. I am the events chair and second vice president of the Decalogue Society. And I'm thrilled to introduce two of my very good friends here, founding members of FLASH, the Force of Lawyers Against Sexual Harassment. And Dina and Rebecca have done this presentation before, and it's so impactful, informative, important. And so I'm really happy that everyone is here. So, first to introduce Rebecca, she is the founding member of Berlin Melzer Law LLC. She has practiced exclusively in family, matrimonial, and estate law. During her time, she is a litigation attorney, a trial attorney. She does appeals, also mediation, and collaborative law. She's a member of the Collaborative Law Institute and the International Academy of Collaborative Professionals, and she's a certified mediator through Northwestern University. Her practice ranges from low to high conflict, parentage, and divorce cases. Frankly, she's just amazing. She's great in a courtroom. She's a great advisor. I'm just going off script now, Rebecca. Rebecca is one of my very, very dear friends. Um, she has been consistently recognized by her peers as a leader in the field, receiving honors by the best lawyers in America, the Illinois Super Lawyers, Rising Stars, emerging lawyer in the areas of family law, and top women lawyers from an Illinois Rising Stars. She was awarded the 2023-24 ISBA Carol Bellows Women and the Law Award um, for those with more than 10 years of experience. And she is heavily involved in the ISBA. She's also very well known in the family law community. Her and I founded the Lady Lawyers Who Lunch, which is a group we're incredibly proud of. Um, she's an executive board member at Shalva, which is an agency providing critical services to domestic violence victims. And she has previously served as a member of the ISBA Standing Committee on Women and the Law. So welcome, Rebecca. And next we have Dina, who is just a dynamo. And if you want to know about sexual harassment and the prevention and the enforcement, I mean, Dina is your person. This is her area and she knows it and she's passionate about it. She's currently employed as general counsel for the Illinois Department of Central Management and is actively involved in a number of community and professional organizations. I mean, Dina, to talk about women supporting women and being a feminist and being in the community, like that is Dina. She sits on the board of Wings, which is an organization that provides a continuum of integrated services in an effort to end domestic violence. She previously served on the Wings Metro Associate Council since 2014. She's very active in the ISBA, being on the Women Law Committee, serving as the legislative chair. She's on the Diversity Leadership Council. She's on the General Assembly. As I said, she's a founding and executive board member of FLASH, which is a coalition of legal professionals working to combat the prevalence of sexism, sex-based discrimination, sexual harassment, and sexual assault within the Illinois legal community through direct advocacy, policy implementation, education, and peer support. She has been the co-president of the Chicago chapter of the National Organization of Women. She has been on the board for the Women's Bar Association of Illinois. And she has been awarded the CBA Vanguard Award in 2023, also the ISBA Carol K. Bellows Women of Influence Award in 2021, and the Women's Bar Service Award in 2013. So a huge welcome to Dina and Rebecca, and I'm going to turn it over to them.
Hey everyone, thanks for coming. So Erin made me sound good. What I am gonna start by saying is I apologize up front for my very basic and inept skills at PowerPoint. So just bear with me, and I hope the content makes up for the lack of presentation, so to speak.
And I also, sorry, Dina, really quick, I just want to know if you have questions during the presentation, please put them in the chat. Rebecca is going to monitor the chat and will chime in with the questions for Dina and herself to answer. So just throw your questions in the chat. Thanks.
Do I have this right? Does that look
You
right?
got it.
Perfect.
You
Dina,
got
you got
it.
it.
Okay, thank you. Yes, I like this to be as interactive as possible. You know, Rebecca's going to have to monitor the chat, but feel free to interrupt or chime in or share whatever you want. Um, I am. I'm going to start out by saying I've done similar programs to this multiple times in multiple venues. I don't know that I've ever had this many men in attendance. And so we love to see you here engaged in this conversation and interested in this conversation. So again, thank you for being here. This is going to be a little bit different than sometimes that I've done this. This is going to be more content heavy. I'm probably going to be reading the slides a little bit more than I usually do. We've been doing this for a number of years, and I think I think we've gotten to the point where we don't have to really go into the various examples of sexism and soft sexism and things we see in the legal profession. We'll get into that a little bit, but there's some big updates in the law, and we've made some even further progress in the last couple of years. So I want to focus on that. I think knowledge is power, and I think that there has been legislation and enforcement over the last few years that have kind of put an emphasis on sexual harassment. And then we're going to talk a little bit about specifically about sexual harassment in the legal profession. I always say we're supposed to be ahead of the ball because we are the ones that are supposed to protect this, enforce it, and we are in charge of implementing laws that are aimed at eradicating sexual harassment. But we have a very significant sexual harassment problem in our legal profession in Illinois and nationwide. So we're going to go through some of that stuff and see where we're at. Hold on. All right. That was giving me a little bit of an issue. So again, not tech is not my not my high point. All right. So these are some general statistics about sexual harassment in the workplace overall. Right. So, and I'm kind of comparing just because of the data to see, I think it's common knowledge that women are subjected more to sexual harassment than men. However, I do want to emphasize and everybody to realize that men do experience sexual harassment in the workplace and outside the workplace. It is just because it's happening in less numbers than women doesn't mean it's any less of an issue or should be paid attention to any less. They're equally valid and it is present. And I also think there's probably a little bit of skew in reporting even further. So when you look at the statistics, it's 50% of female lawyers, specifically talking about lawyers that have experienced some form of unwanted sexual conduct in the workplace compared to only 6% of men. 1 in 4 females who experience sexual harassment avoid reporting it significantly due to retaliation fears. And when you look at it when they talk about retaliation, what happens is when you look at 1 in 6 female lawyers, which equals 16%, have lost career opportunities, advancement, and other assignments based on retaliation for reporting sexual conduct in the workplace, and only 1% of men. So when you look at the reporting and the experience in proportion, and then the negative consequences that are given to women more significantly than men experiencing the same thing, that's a statistic that I think is important. And then when you talk about sexual harassment when you take away the direct sexual assault or sexual advancement, and you really boil it down to kind of that soft sexism and the jokes and the demeaning comments and, comments on looks, that goes up to over 75% of female lawyers. I think you're going to have a hard time finding a female lawyer that doesn't have some story for you of what they have witnessed, experienced across the board. I think those numbers should be staggering. I really think it is something that when we talk about the prevalence and we're talking about Flash and coming together as women trying to combat this in our profession, that's what we're looking at. You're talking about pretty much every woman has experienced that to some degree. So the first thing I'm going to talk about is they pulled the data in 2019. They put out the statistics in 2022. The Women Lawyers on Guard is a national nonprofit organization specifically looking at sexual harassment nationwide within the legal profession. They're an amazing group, and this is the first real comprehensive study of sexual harassment in the legal profession nationwide that ever occurred. And we got a lot of insight. It's called Still Broken. It's easily you can easily find it on Google. I really suggest you go look at that report. There's a full report and executive summary. We're going to go through a lot of the statistics, but they really came up with some very interesting stuff, and it's a very easy read. It's a lot of graphs to help you. Not a lot of words, but it's fantastic. So they looked at when they were polling the people, they asked for the 5 years before 2019, what have you experienced in that 5 years? Not over your whole career, but just more recently. And so when you look at incidents of sexual harassment, one of the things I thought was interesting was it is more prevalent in law firms than it is in a government setting, in law schools, nonprofit, corporate, or bar associations, right? So the most sexual harassment you're going to see in the legal profession is concentrated a little bit less than half in law firms. I also think it's interesting if you look at where the sexual harassment is occurring in the legal profession, 37% of it is in group settings and 22 occurred in social settings. So you're looking at about 55% of these incidents being in group settings with other people witnessing and allowing that kind of to happen, right? So that's how, when I look at it, I think it's perpetuated because, a lot of times people are either caught off guard or don't call it out when they see it. But those two stats together, the 37 and the 23, is over half of those incidents are out in the.
Dina, you just muted yourself.
I didn't even touch anything.
It was magic, but you're good now.
Sorry about that. Only 23% is occurring in private settings, right? And so I think it's significant to note that this conduct is out in the open and accepted because it's not just happening behind closed doors. Obviously 91% of this still misconduct and harassment are perpetrated by males. Again, that's just a stat. It is what it is, but it goes both ways. And so I also thought it was interesting that while the numbers are lower, the higher you get in partner status or, judicial status or general counsels, it's still there, right? So you're still looking at supervising attorneys and partners of law firms are getting sexually harassed at 16%. That's still pretty significant considering you're supposed to be at the top tier of the organization. So it does not matter where you are. These women are on the entire spectrum of our profession. Okay, so
Dina, I'm gonna interrupt you for a second.
Sure.
There's a question in the chat that I think could be addressed now. It says, what is sexual harassment? Is it looks, touching, words? Is it worse if a supervisor is involved? Is mere asking someone out on a date sexual harassment?
Any member that has access.
So the definition of sexual harassment is unwanted conduct of a sexual nature, right? So it's everything from soft sexism to sexual assault, right? I'm going to give you an example of soft sexism that I think we see a lot. And it's and when I've brought this up before, people don't realize they do it. But you will often see men in a litigation context in front of a jury refer to the male attorney on the other side by their Mr. So-and-so and the female attorneys by their first name. I've also seen it in emails where they are addressing a male, like two partners are on an email and the male is Mr. So-and-so and the female is, Jill or whatever the name is, right? It's from that, it's from assuming a woman walking into a deposition is the court reporter and not your opposing counsel. It is all the way up to touching, making perverse jokes, commenting on people's bodies. I'll tell you one thing I've been seeing. We're in the holiday season. There's parties. We are also in the era of Ozempic and weight loss drugs, and a lot of people are showing up, losing a lot of weight. The amount of comments I have seen in public of people just overtly commenting on people's bodies and appearance and their weight loss in professional settings is unacceptable. And I don't know why people think it's okay to just walk up to somebody in a professional, even if you're trying to give them a compliment, it's just not appropriate in a professional setting. So the conduct goes all the way through the variations, right? But it's any unwanted sexual conduct, right? You shouldn't have to go to work and be asked out on a date, right? Now, we know plenty of people have started relationships in the workplace that is consensual. So there's a way to do it, but it's unwanted. And you shouldn't assume that you can talk to somebody that way. And you shouldn't assume at a bar association social or a firm party that you can talk to women the way you would in a bar. Not that you should talk to women in a bar inappropriately either, but that, there has to be some acknowledgement of the conduct in a workplace is different than a conduct outside.
Well,
And
Dina, I always think like in the workplace, like especially being a court litigator, would you say that in court? Would you comment about someone when you're in a professional setting in court that way? And you would never do that. And so especially in the holiday season when you're out and about, like it's not just physicality, it's your words and how people receive that. And just kind of while you may be in a different forum, think about it as if you're in, not a bar, not a holiday party, but you're in a courtroom and how would you act and act accordingly?
right, and we're sitting in a group setting where it is your opposing counsels, your judges that you appear. Nobody wants to be commented on or talked to inappropriately. I'll give you the example of one time I was at a social event and I walked into a conversation and some guy was looking at one of my friends and being like, "Oh, come on, you can't be a lawyer. You're a court reporter. You're too hot to be a lawyer." And I was like, I don't know if that's more insulting to the lawyer or the court reporter, but also, what are you talking about? And like, I went a little bit, I called them out and the reaction was like a little bit like, oh, whoa, 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 whoa. And then walked away and somebody came up to me and said, "What were you yelling at Judge so-and-so about?" And I was like, "Well, I didn't know that was a judge." And then I was like, "Well, if I knew he was a judge, I would have said even more." Like, you know what I mean? It's just absolutely inappropriate to have to hear that. Like, that is just not something you should say to anybody, let alone when you are supposed to be in a robe and people are supposed to be comfortable sitting in front of you. So,
No, but kudos to you for speaking out. And then I'm going to mute myself and let you go back to the slideshow answering this question because I think destigmatizing this is super important to allow people to have the conversation, to feel comfortable. And I know we've done this presentation before, and you've said you may not be comfortable speaking out, but someone else will, right? Because the person who might be speaking out or being on the receiver end of that sexual harassment may be very uncomfortable standing up for themselves. And so I think as a community, it's not just looking out for yourself, it's looking out for others. And when we see something, say something just to elevate ourselves as a profession.
yeah, the other thing to add to that one of our colleagues has told us that has stuck with me very much, and I've never thought about this before, is that sometimes when people are receiving that information directly, that it's targeted at them, that they freeze up, that could be a trauma response that person is experiencing based on something else they've experienced in their life. So just because someone isn't calling it out or reacting doesn't mean they're okay with it. Right. And that we have the duty to protect each other and to demand better of the conduct in our profession. As far as the liability part of that, when we get into the Workplace Transparency Act, I'll address that part of that question. So when this Women Lawyers on Guard, 70% of respondents who reported they experienced sexual harassment said it was part of their workplace culture. 70% of people who responded to this study said part of their workplace culture was going to work and being sexually harassed to some degree. And I do want people to get their head around that. That does not talk, it's not just sexual assault. It's not the boss hitting on you or backing you in or trying to kiss you. There's all kinds of levels of sexual harassment that's inappropriate in the workplace. It's defined in multiple laws. And that being part of our culture, that isn't an office culture. That's a legal profession culture. That's the boys club, right? And I always say, the boys will be boys. And I'm not trying to target men, but that's kind of what you get. Oh, they're just making jokes. Oh, it's male. And you see it everywhere in male dominated industries. And it's rape culture is really what it is. And I am going to be hard pressed to not bring up the 20-year-old welder who recently was bludgeoned in the workplace by a male coworker just because he didn't like her. That's what he said. I didn't like her. And he bludgeoned her to death with a mallet in the workplace. And so that is when you're talking about workplace culture. That's when you're talking about sexism and sexual harassment in the workplace. That's why it's important. That's not the only reason it's important, but those are the extreme cases. And that is 3 weeks old at this point. And that gentleman had been harassing her multiple times and she had went to HR multiple times about his conduct and nothing was done. And this is part of the reporting problem we're seeing here. Like only 14% of people that experience direct misconduct in the workplace reported it. And which leaves 86% of people not reporting it. And that is, and most of these that were being reported in this study were in fact actual sexual assault, stalking, like, that high level of conduct, not really the soft sexism. 40% of those who did report, and again, we're only talking about 14% of people only reported. 40% of those 14% said they either received actual harmful consequences as a result of reporting or no support at all. And that's why it doesn't get reported, because when it does, all it does is help or hurt the person that is reporting it, not the perpetrator. 50% of those that reported sexual misconduct in the workplace, in the legal profession, stated that their perpetrators never faced any consequences. And another 20% of them said they don't know if they did or not, because they were just never responded to or never got the benefit of that knowledge. So that's 70% of the people who reported misconduct directly in the workplace. Either there were no consequences for that action or little known, and it definitely wasn't made public. This is a direct quote from the study that I like, that the impact of those being harassed and the fallout for those people is much more profound and debilitating than the consequences for the people harassing them. And so when people are asked why they are hesitant to report, these are what they say: fear of job loss, negative repercussions, that the harasser is their direct supervisor, and if there's no consequences to that action from a direct supervisor, that they're just going to get retaliated against, and it's going to affect their career negatively. There's also a significant amount of people who are concerned for their own safety, and what's going to happen to them if they do in fact report it. And there is also the doubts of being believed, right? So this goes back to, if everybody knows the scenario online that got everybody outraged, where they asked women if you'd rather be in the woods with a man or a bear, and every single woman said a bear, and nobody understood it. That's really what it is. It's because if I get mauled by a bear, no one's going to question what I did to provoke that. Nobody's going to ask me what I was wearing when the bear provoked me. And you pretty much know what a bear is going to do to you. You just don't know what the consequences are. But a lot of what people say why women chose the bear in that situation was the reporting and the lack of belief in their story and what they did to deserve that conduct, which goes back to, what we're seeing reported directly here in this report. So shortly thereafter that, a lot of us worked together, different bar associations, Flash, and worked with the Illinois Supreme Court on professionalism, where they put out a survey, and we wanted to kind of see if we could get some insight into sexual harassment in the legal profession, specifically in Illinois. So there was only a little over 1,500 attorneys who replied. I did like the fact that half were men, half were female. And then there was 4% and another 6%. So another 10% were either gender fluid, non-binary, queer, or didn't report. So we do have a good spectrum here. It wasn't just women reporting. I will say this: when you look at this, we did not get any data from anybody over firms of over 50 people. So we did not get any data from large firms. This is smaller, more intimate firms, or mid-sized firms, just to keep that in context for whatever that's worth. It did not focus just on sexual harassment. It was incivility all over in general. And they were looking only at the 6 months prior to the survey going out. There was over 3,000 incidents of incivility reported, which I think is a problem in and of itself that isn't related directly to sexual harassment. But 100 of those were related to sexual harassment within the 6 months previously. And then there is also some knowledge about whether there is sexual harassment training in your firm, whether people know about that training, and those statistics came out from the study as well. So we'll go into the Workplace Transparency Act that was passed now in 2020. I think most people are generally familiar with this. This is where the sexual harassment training is now required. This is where this came from. This initially was a 280-page bill combating sexual harassment in Illinois. It's very comprehensive. I am hitting very high highlights. This is a comprehensive bill that keeps getting amended and built on. So it is a very piece of important legislation. It did some of the big things, the expansions it did is what created expanded sexual harassment prevention to not just employees. Now it's consultants, contractors, vendors, things like that. So if your employee is sexually harassing a vendor or a consultant, you are now liable for that as well. So this took sexual harassment and misconduct out of the workplace and expanded where it can happen. We're going to go into some of this, but there was also they limited how you can put non-disclosure agreements or mandatory arbitration clauses related to harassment, discrimination, retaliation in contracts, employment contracts on the front end or settlement contracts on the back end. They started to increase transparency there. And so here's the liability issue. So in Illinois, if you are a supervisor, your employer is strictly liable for your conduct, period. End of story. Okay. Your supervisor's conduct is your conduct. And so if you have supervisors who are perpetrating this conduct in the workplace, you are strictly liable for that conduct. For non-managerial employees, once you know or should have known that that conduct is taking place and you failed to remediate it properly and put reasonable corrective actions, you are then responsible. So what is happening is if you have a pattern, right? And so if sexual harassment is reported and what you see is there's no consequences and this is a pattern of behavior that you're allowing to take place in your workplace, you're now liable for that conduct for allowing that pattern to occur and to continue. And so those are the differences in liability. Okay. So, and then this is again where all employers were required to provide sexual harassment training at least once a year to their employees. Even if you only have one employee, if you don't know this, you have to be compliant with this law, or you should be. You should have a sexual harassment, anti-sexual harassment and discrimination and retaliation policy, and you should have training once a year. The Illinois Department of Human Rights, in response to this Workplace Transparency Act, has put a training on their website that you can use. So you don't have the burden of creating it, developing it. You can take it right from IDHR. They provided that for you. And the other thing now is if you are hit with claims or complaints of sexual harassment, the Illinois Department of Human Rights can now make employers disclose settlements related to conduct of sexual harassment or discrimination for periods of 5 years. So if you're going to get hit with that complaint and they find some eligibility, they have the ability to tell you, I want to know all the sexual harassment complaints and settlements you've had in the last 5 years. So there's some accountability that is being looked at here statewide.
And Dina, I think that accountability is so important because so many of these resolutions, when I don't call it resolution, but agreements have a non-disclosure policy, right? So the person who's a victim of sexual harassment brings something up, ends up getting terminated, wrongfully terminated, and then the employer has a non-disclosure. And so at least it allows to see if there's a pattern in practice of just disregarding that behavior internally.
Right. And so in direct response to that, right, in August of 25, there was an amendment to the Workplace Transparency Act that goes into effect January 1st of 2026 that even strengthened and kind of carved out some exceptions for practical purposes. And so I wanted to go through these amendments. These are the newest upcoming pieces of legislation that I think everybody should be aware of. So what it did is it expanded. It doesn't just say harassment, retaliation, discrimination. Now it talks about unlawful conduct. Okay, so I'll tell you what that is in a second. But so now employers have increased obligations regarding employment contracts and and settlement agreements that includes unlawful conduct all the way around. This affects your settlement agreements, your termination agreements, your arbitration agreements, everything having to do with that conduct. And there's always there's a carve out now for unions because that got a little sticky in certain situations. So this is the expansion of unlawful conduct isn't just discrimination, harassment, or retaliation anymore. It is any unlawful practice that is actionable under these different agencies, under state or federal law. So it's the Illinois Department of Labor, the Federal Department of Labor, the OSHA, the National Labor's Board, the EEOC, the Illinois Department of Human Rights. Anything that those agencies are regulating, all that conduct that they regulate is now incorporated within the Workplace Transparency Act.
Hey, Dina, before we go to some of these updates, we do have a question about whether a workplace includes where someone volunteers, like a volunteer fire department, a Boy Scouts, other volunteer work that, people do.
Are you asking if you're a volunteer at an organization, whether that you have those protections? You do. That's the same thing as the consultants, the contractors, or what have you. So if you are volunteering at a police station, right, like, and you're getting sexually harassed within that volunteer work, that employer is still responsible for the conduct happening within their workplace.
Excellent. Thanks for that guidance.
Sure. Right. And so the other thing these updates to the Workplace Transparency did is protecting employees' ability to engage in concerted activity for work-related issues. So this includes the right to collectively bargain and organize, work-related issues regarding benefits or salaries, right? So this is like the no salary history thing, expansion, where if your employees are going around talking about their wages to see if there's discrimination in wages, you can't prevent them from talking about that anymore. That's protected in here. Individuals' right to report safety concerns to OSHA, that's now covered in here. Right. So that's all their concerted activity. It expand a little bit further to employees' abilities. You cannot limit your employees' ability to testify. And this is current employees, prospective employees, and former employees, right? So you cannot contract or settle something and prevent them from testifying in front of a tribunal, an administrative agency, or a court about that conduct that took place in the workplace. So you may have settled out with that employee and resolved your issue with them, but you cannot prevent them from talking about it when somebody else has a case or in another matter, or if an administrative agency is trying to take action on something like wages or safety. And you can't prevent them from sitting for a deposition or answering a subpoena, any of that. That is all off. You cannot include that within your settlement or your contracts for employment. So, and then there's additional with your employment contracts. You can't, the employer cannot unilaterally do things like identified here, shorten the statute of limitation, apply at different states. We have good rights here in Illinois, right? Our legislature has worked very hard to protect civil rights and other things in this state. And so a nationwide employer can't require you to go under an arbitration in a different state under a different state law, and contract you out of being protected by the Illinois law where you are working, or require you to go outside to adjudicate your claims. That's no longer allowed with these amendments. There is a little bit more flexibility if there is truly an agreement, and there is I didn't go into a whole lot of specifics, but if you are an employer that is trying to create an employment contract that limits any of these rights, I suggest you look at what those restrictions actually are. And there has to be, it can't be unilateral. It really has to be a mutual desire. And this I think is very interesting, is if there is any kind of confidentiality agreement as part of your settlement, there has to be different consideration. So you're going to have to pay for it or bargain for it in some other way. It isn't automatically just throwing that clause into your settlement contract. Again, while there are some confidentiality clauses that are allowed, those confidentiality clauses cannot prevent people from that concerted activity. So, right, confidentiality, even if it's in your contract, doesn't prevent them from appearing to provide testimony in an administrative agency or a court of law. And you cannot unilaterally force that on. You can't put in a contract that it's the employee's preference or the employee wanted to do that if that is in fact not true. It can't be in your form without having other kind of consideration or talk with the employee that you're bargaining with. And again, the concerted activity has to be up. So I'm just going to real quick go through, just for awareness, of one of the problems we have in combating sexual harassment in the legal profession is our rules of professional conduct are very loose and very broad. And so, right, so 4.4, Rule 4.4 is one of the provisions that pretty much falls under where you can make a charge or an argument against someone's conduct. And it's very, very loose. And nondescript, right? So there's 8.4D and 8.4J. The problem, here's the problem with this. 8.4D, it can't be prejudicial to the administrative justice, right? A lot of this sexual harassment isn't directly related to your case. It's kind of on the side, right? And so that doesn't really provide you any cover. Now, we have examples where it has been directly related to the administration of justice. There's been a case where opposing counsel accused a female attorney of sleeping with a minor child in a divorce case, the teenage child of the opposing side. So that's right on the record as part of the case, and I think that's directly actionable under this provision. But most of the time, this is not happening in the profession. It's in the professional setting, but not in a professional context. It's not directly related to your case. So 8.4D doesn't really do anything for anybody protection-wise as far as sexual harassment is concerned. And the problem with 8.4J is that it has to be a violation. Like, it has to rise to the level of either being a crime or actionable in some other way. If it doesn't rise to that level, then there's no protection for anybody here, right? So our rules are really lacking teeth for individuals to report to the ARDC and get some real consequences from this action, unless it's extreme. And that's also a reason why this is kind of perpetuated in our practice. And so this is the proposed rule, the 8.4G. I'm sure people have heard about this. This has been going on for years. There is a back and forth discussion and controversy about this rule. The ISBA has tried to address it. Multiple other forums have tried to discuss this. This is what we would like to get into place so that there's some actual teeth behind consequences to this conduct. And would get some teeth to things that happen in these social settings that we are all very much engaged in, because we are social creatures, which is one thing we love about our profession. But this has always been based, the argument against this has always been based that it's freedom of speech and such arguments. And so we are still, this is an ongoing battle. But there has to be something with more teeth than we have now. And so people come and fight this proposed rule when it's proposed, but they never really provide an alternative. And so I am just going to give a shout out to one of our beloved members of Flash, Katie Liss, who did an amazing job with the CBA in 2024, who expanded the Supreme Court rules for CLEs. So now sexual harassment prevention and the CLE, like we're doing today, now falls under the professional responsibility credits as part of our CLE requirements. This was huge. It was a great argument. I wrote an article about it in the ISBA. I was shocked by some of the questions that she was getting when she was just, all we were trying to do was allow this and promote these kind of programs as part of the professionalism credit. And some of the pushback was shocking. Again, I'm going to say that goes to the prevalence in our profession as this being part of our culture.
And I think, Dina, this is sort of a good segue to talk about Flash. And so the participants understand. And like you said, I'm so appreciative of everyone who attended, but especially the men. I think in order to eradicate sexual abuse and harassment from our profession, it needs to be a collaborative effort with everyone. And as you said, we've spoken before on this issue, and we have lots of women show up and everyone has a story, as do men, but we haven't necessarily gained as much. And so I think that says a lot about everyone here and about the Decalogue organization as well. But I wanted to let everybody know about Flash. We keep talking about Flash without necessarily even saying, although it's right here, it's the Force of Lawyers Against Sexual Harassment. And Katie Liss is amazing and helped modify that Supreme Court rule, but we are basically a task force of Illinois professionals in many different from many different organizations and private practice, public, united to study and make recommendations and combat the prevalence of sexism in our practice, which is significant, sex-based discrimination, sexual harassment, and sexual assault. And we have done this through CLEs, just like this one, informing people through direct advocacy. We're working on policy implementation, education, and peer-to-peer support, helping provide peers necessary resources. We don't provide them ourselves, but just connecting people. Our website is flashillinois.com. Maybe Erin, you can pop that in the chat. I can't multitask as well as I should. And we
It's
also
on the slide.
Oh, great. Oh, thank you. It's also on the slide. I don't know if someone can tag it though directly, like link it. I'd love for you to click it. There is a pledge that we'd love to have you join. And basically, I mean, look, this is something that we need to eradicate, and we need to act in a way that's professional, in a way that is consistent with the laws that we are drafting. And as Dina sort of went through, like, this is a problem. All of the data shows that this is a problem in our workplace, and we know it. And so I think it's just standing up, educating ourselves, and speaking up against it, because it's not okay. And still, it's just uncomfortable bringing up when there are issues. And as Dina said, there's reasons why, right? You are punished for bringing up a concern. And so rather than speak up about it, people stay silent. And so I think we're number one looking for people. If anybody wants to support the Flash initiatives, contact myself, contact Dina, contact Erin. All three of us are on it. There are a litany of other attorneys involved, and you can see everybody on our website. And I just think just the volume of people here speaks resources to how much people want to do, and sometimes they just don't know how to do it. And so we're here to support you in that endeavor, and hope that you are able to sign our pledge and participate.
And I'll throw out a couple other calls to action maybe for those
Okay, go for it, Dina.
on this call. So if there are any judges on the, I'm sorry, I can't see everybody. So
Oh, I saw Judge Shapiro. I don't know if he's still here, but I'm going to call him out. I can't see him on my screen.
Shapiro's already heard this from me.
Oh, he's raising his hand. I see him. He's a big supporter, and we appreciate it. Sorry, Dina, go ahead.
But so any judges or any judges you know that you're close to, please encourage them to put in their standing orders a statement against sexual harassment, discrimination, and retaliation in their court.
Absolutely. And Dina, you reminded me that we worked alongside the judges in the Domestic Relations Division to make changes to our local rules on civility. And again, you think, okay, it's just a rule. We're rule followers. We want to follow the rules in our profession. And it's really nice. Just before this seminar, I sent an email to a group of 7 lawyers and said, guys, this communication via email is not civil. Let's take it back. We know it's the holiday season and stressful, and let's go back to reality. And just kind of like reduce the steam. I couldn't believe I said that, and I cited the local rule. And so sometimes just having it in a form like a local rule, like your standing order, it's super important to point to, and it shows how seriously you take this important issue. And Elliot, thanks for signing the pledge. I love your chat, and I kind of would love to encourage everyone in this 50+ person seminar to join.
Owners of law firms, having that kind of statement on your website or known to your employees as onboarding, that you take that serious and that is not tolerated in your environment, it goes a long way. We get a lot of pushback when we say these things. It's like, how do you actually enforce that? I won't go into that because I just told you all the ways you enforce it, and we should be enforcing this conduct occurring. But just your affirmative statement that that conduct is something that you don't tolerate as a group, as an organization, goes a long way. Decalogue as well. We've worked with bar associations to have a code of conduct for a bar association, that conduct is not tolerated within the bar association. We got that done with the ISBA, and it's important. So, if everything stays the same, the more you start seeing those statements around, the more you saw pushback with, Me Too and Illinois Say No More. I mean, Illinois Say No More, if anybody is unfamiliar with that, were the staff of the legislatures of the Illinois legislature pushing back against sexual harassment that they experienced. Myself and Bridget Dugnan, who is now the current ISBA president, at the time were legislative co-chairs of the Women's Bar Association. We testified at that hearing for them to change that bill because we experience a lot of the same conduct that they experienced. And that resulted in them getting an active inspector general focus on sexual harassment for the first time in a decade for the Illinois legislature. So there are, pushback going back in certain industries. And I encourage everybody to get involved to some degree on not tolerating this within our legal profession.
Dina, we have a question
Yes.
from someone in the audience. What is your opinion on speaking up at work about sexual harassment and retaliation? I have some opinions on this. I think many people want a new job after experiencing it at an employer and move to an employer that doesn't tolerate it, but it's hard to get a new job.
Sure. I mean, unfortunately, this is part of it, right? Right. This is why it doesn't get reported, because of the fear of retaliation, right? And we all know that people talk, and I'll never be amazed at how small of a big city this is, especially when you boil it down to the legal profession. This is why we created Flash. This is why we want to create and expand and grow a coalition of lawyers who won't tolerate that. And so, I would. It's gonna be a shift, right? To that individual, like, we would like to act, Flash would like to act as a resource for you, help you do that. We're never gonna tell anybody you have to report it because you're the one that has to deal with the consequences. What I will say is there's a bunch of women that will stand behind you if you do it. I had a friend file an ARDCB for some inappropriate conduct that she experienced by her opposing counsel. And we filled that ARDC room so much that we had a standing room next door. And so it is, I would encourage there to be some talk about the people who are perpetrating this conduct, and encourage that narrative of and their reputation, rather than the victimizing the people who were the subject of the sexual harassment. We all see the headlines, right? We all, I don't have an issue calling people out, right? We all know what Dave Pasulka has been, accused of. We all know what former Judge Bill Raines said on the record. This is conduct that's out there, right? And not talking about it and protecting, that conduct is part of the problem. But I hear that there are some people that are going to be comfortable speaking out. There are people that will speak out with you and for you. But it is right now, it's a hard move to make sometimes because there could be consequences for your career. And especially as a new lawyer, it's hard. And it again is why we created Flash. And
there's
why
another
we are trying to
question.
go into bar associations and other organizations to talk about this, so that people know that there are other people around and allyship in this journey.
And there's another question I just want to address, especially I think if you are experiencing sexual harassment in your workplace, I think you have to decide if it's a place that you want to stay or you want to leave. Because if it's a place that you may want to leave, there may be some strategy in getting a new job and then addressing it after the fact to help prevent other people from experiencing that as well. As Dina said, it's often used against you as a sword. But another question of what can you do if a client is the one perpetuating sexual harassment and the partner or firm owner does not take action? So it sounds like maybe a client is inappropriate with an associate, an attorney, What are the next steps to take?
Again, I would say call it out and
Yep.
you know, tell them it's inappropriate, you don't appreciate it, and then you know, we're in a professional setting. Please refrain from, you know, treating me or talking to me in that way. Um, if there is another attorney you can bring into those conversations to have as a witness or as a backup, if there's a way to get out of that case for that conduct. So this is another thing I'm going to say that's very important, and this is another call to action to people like on this call and your friends. This is why mentorship is important inside and outside your workplace, so that you have somebody in your firm that you can go to when you have these issues, or somebody you can go to that's a member of a bar association or another thing, or just another ally you can go to talk these out in real specifics. It all depends on the dynamic, right? But like, you would hope that there's somebody at the law firm that can help you maneuver that. But again, sometimes you've got to do what you do to get out of that situation. And then when you're out of that situation, I encourage you to call it out for what it is. Because it's the only way things are going to change. But if it is a client, it's a little bit more difficult. But I would think about if there's a mentor you can go to how to manipulate that, have someone with you when you interact with that individual and call that conduct out. I recently gave a training to a bunch of trades guys, and I had a gentleman get very upset, and at one point was like, "This is America. Can we even do anything?" And I was like, "I'm sorry, you're upset that you can't sexually harass people in the workplace anymore, but times are changing." And I couldn't believe how exasperated the man was that like he had to watch what he was saying in the workplace. And so I reminded him, just like your union contract regulates your workplace and lots of other code of conduct regulates your behavior in the workplace, this is one of those things that can be regulated as well. And by the way, it violates the law. And I encourage everyone, you know, we are the arbiters of law. We are the protectors of law. We are violating the law when we engage in this conduct. I encourage that narrative to be part of it, right? Like, we are supposed to do better. We are supposed to be better. We are the lawyers. I know that on the big scheme of things, that's hard to hear right now with a lot going on within the legal community overall, but we have to do better.
There's one more question, and Howard, speak up if I'm not saying it right. It's in your opinion, what is the most minimal harassment and what is the most minimal non-harassment? I'm not sure I fully understand
I
what you're
think
saying.
maximum. I think he's saying maximum.
Maximum?
Like, what are the scales? What are the scales that maybe you've personally heard
Yeah,
of?
so the bottom end is the soft sexism, the refusing to call a woman by, you know, in the same, treat a woman the same way as her male colleague, going around a woman to the male colleague, like, right? There's all that kind, you know, don't ever ask anybody if they're the court reporter until you see the stenographer stuff come out, right? Don't assume that, right? It's that soft sexism.
I'll give an example of that. I was a young associate and I showed up to a deposition with two partners from a big name firm and an associate and just me. They noticed it, didn't notice it for a video deposition. I said, I'm not doing this as a video deposition. You could take a non-video. And they said, well, we'll wait till your partner's here. What he can handle it as a video. And I said, no, you won't. I'm the one defending this deposition, and you can either, I'll sit here for 3 hours until this deposition is done because you're getting my client now. So take the video away or not. They would have said that if a guy showed up. If a young male associate, I'm sorry, they never would have, they wouldn't have given me the time of day. And so I had another deposition where I was a young lawyer and I was very nervous, and someone was just being very rude, interrupting to interrupt, throw me off. And I said, I'm going to print this deposition and I'm about to pee in my pants as I'm doing this. I'm going to send this deposition transcript to the ARDC if you keep treating me like this, right? It's just the way you treat a male sometimes is not the way that sexism you're going to treat a female. It's undertone. It's not there. It's not you can't tell it necessarily, but it's how they're treating you.
And
It's
I will
also
just chime-
it's also
oh,
the
go ahead, Dina.
No, go ahead, Darren.
I was just gonna say I uploaded an article shortly ago in the chat, and I would really encourage everyone to read it because those are our stories. That's how Flash started. Flash started because our friends, our colleagues, started after the David Pasulka scandal came out. we all started talking. And so you may not know that the people in which you interact with have experienced what they've experienced. So it's important to talk about it. And I think that it's getting better. Like we're talking about it more in the open, we're speaking with young women to make sure that they're feeling safe, that they're at good firms, that they know we're here to protect them. But Flash originated and these trainings originated and these laws originated out of our real experiences and experiences that we actually went through and our friends actually went through. Katie List's article is based on our stories. And we didn't talk about it then. And so that's why it's important. So I would encourage you to read it. I would encourage you to speak out, speak up, talk to other people, talk to the younger associates at your firm and make it clear that it's not going to be tolerated. There's a zero tolerance policy. Make sure you have it in writing, to Dina's point. But this is happening and it has happened and it's real. And again, read this article that Katie put together to see that, like, and to know these are your colleagues. These are the people that you appear in court in front of, have gone through this. And so it's not someone else or whatever. It's the people you know.
And I will just keep like and add to like the scale, right? The other thing we see a lot is the way you use adjectives differently for men and women. I had a friend be told when she was interviewed for partnership that she was too assertive. I don't know why assertiveness is a bad trait in a lawyer, first off, but men are confident, women are aggressive, right? Men are passionate, women are emotional, right? That all plays into, right, the adjectives, right? Like the conduct from a woman is very different than the conduct of a man, even though it's the same conduct. They're viewed, they're classified differently, right? When you move up the scale, you start going into inappropriate comments and jokes, right? Think about Clarence Thomas's confirmation hearing, right? That was all inappropriate comments and jokes made to Anita Hill in a workplace setting for the EEOC, by the way. But right, and then making comments on people's bodies, like what they're wearing, telling your female associate judges to wear the shirt with a lot of cleavage in front of a specific judge because it'll get them farther. That's unacceptable, right? All the way up to, the extreme is obviously sexual assault, right, and rape.
Well, and Dina, I think that those things, the ones that those are extremes, they're so obvious, right? It's like, the really inappropriate groping, touchy, those are like the ones that you sort of are easy to see, right? Those are the ones that we don't, as a it happens, but we all know. It's kind of reading between those tones and really educating ourselves about the minimal, and I wouldn't call it minimal harassment because I think it's all harassment. I'm not, everyone gauges it differently and receives it and processes it differently, but it's those types of sexual harassment, inappropriate sexism that I think we all really need to continue to inform and educate ourselves about, because sometimes it's just hard to tell and call out. And not always is it done like in this malicious way. Sometimes people don't realize, oh, I said that, I'm an idiot, right? And you appreciate that response because they can learn quickly and we all make mistakes. It's just calling it out to make sure that we don't keep doing it.
There's one last question. We're about 2 minutes left. So we have one last question in the chat. Because I feel like some male lawyers act like this just for the competitive advantage, intimidation effect. I may not actually feel that way. What is your opinion on that?
I mean, that's
I think it's a culture. Sorry, go ahead. Zane. I mean, look, like, you get sometimes a bunch of people together, and if you want to be part of this culture and cool boy status, I'm going to follow along. And it's especially hard, I think, for the younger group to speak up when they see their mentor acting in a certain way, right? So, I don't know. I don't think it gives a competitive advantage. I think it just shows a disrespectful way of acting. And I think we all have to own our own actions, right? At some point, it's not just like, I don't know. Dina, what do you think?
I'm going to say that if you think you have to harass or discriminate against somebody and for a competitive advantage, you should probably work on your lawyering skills.
Yeah. That's a boom way to end this. Go be a better lawyer. Go be a better lawyer.
If you're going to try and intimidate me by that conduct, then I'm probably beating you.
Dina, are you saying you won't out sexually harass that person in their conduct? You'll just out lawyer them? I just want to be clear about how that behavior. Yeah.
I mean, if you think that gives you a competitive edge as a professional lawyer and as a litigator, as an advocate and a protector of our laws,
Not at
maybe
all.
you should look somewhere else for your protection. Like that
Well,
is not,
So with that, we're at the 1:15 mark. And so I just want to say thank you so much to our speakers. I mean, you guys did a fabulous presentation, and I really want to say thank you to everyone for coming. And I'm so happy to see so many men here because a lot of the sexual harassment trainings and seminars, as Dina said earlier, it's a room full of women, and it's really important. And I'm so grateful to see so many men here. I want to give one shout out to Judge Shapiro because he has been just such an advocate, so much at the forefront for the judiciary, for men. Just so strong, and we are just really, really grateful, and we want to acknowledge that. And I don't have anything else, so thank you so much. And Aviva, did you put the in the chat? Did we have
I didn't see it this for the
okay,
CLE.
so the survey just went up. So everyone please take your surveys for your CLE credit. And we hope to see you at our other Decalogue events and other Decalogue CLEs. Thank you.
Thank
thank you,
you.
everyone.